Have you ever found yourself navigating the world of property, maybe buying a new home, inheriting some land, or even just sort of wondering how property ownership actually works legally?
Mm-hmm. Behind every single transaction, every deed, there's this complex legal framework holding it all together.
And it's fascinating because this framework, while it sounds really old, is actually designed to be
Right.
dynamic,
Exactly. It adapts. It stays relevant, even through massive changes over the decades.
which is why today we're doing a deep dive into a real cornerstone of property law in South Africa, the Deeds Registries Act 47 of 1937.
Now, 1937 sounds, well, ancient, doesn't it?
It really does. You picture dusty books and, quill pens, maybe.
Right. But this act is anything but dusty. It's alive, it's the bedrock, and it's constantly being updated.
Mhm.
I mean, there were revisions as recently as December 2024.
Wow.
It got the official nod back on May 19th, 1937, kicked off on September 1st that year, originally signed in Afrikaans by the Governor General, so it has that historical weight.
But it's still evolving.
Absolutely. It's proof that good legal drafting can last, if it's allowed to adapt.
So our mission today, we want to unpack this act for you. Whether you're just curious about how property works or maybe you're studying law, we want to give you a clear, engaging look at it.
We'll look at its main purpose, key parts, a bit of the context behind it, what it means practically, and why it still matters so much today.
Okay, let's start right at the foundation. What was the big goal back in 1937, and what is it still trying to do now?
Well, the official wording is to consolidate and amend the laws relating to the registration of deeds. Basically, the aim was to create one single reliable system for all property records right across the country.
Because before that, it was more fragmented.
Yeah, exactly. Different systems, different places. This act brought, much needed uniformity and order.
And that order depends on these physical offices, right? The deeds registries.
Correct. They're the hubs. The responsible minister can set them up, close them down, name them, define their areas.
And that's not static either. You mentioned name changes.
Right. We've seen it recently, reflecting provincial identities. Pretoria Deeds Registry became North Gauteng. Johannesburg is now South Gauteng. Tada became Mfafa. Nelspruit is Mbumbula now. It shows the system keeping pace, administratively.
So not just names, but reflecting real shifts. And Section 1B says a registry area can cover different non-adjoining regions. That sounds interesting.
It allows for flexibility, probably for efficiency, makes sense geographically sometimes.
And some registries have special jobs, like Johannesburg.
Yes, the Joburg Deeds Registry has a specific focus on documents for immovable property in townships within its area, plus some other unique documents. It shows how the system adapts to different land types, especially, dense urban areas.
You mentioned consolidation earlier. How did the Act actually manage to pull together all those different systems, especially with South Africa's history and the changes after 1994? That must have been quite a task.
Oh, it was huge. That's where Section 1A comes in the bit about discontinuance of rationalized registries.
Rationalized registries.
Yeah, think about the deeds registries that existed under older laws, often in the former homelands, Bophuthatswana, Ciskei-Venda, KwaZulu, and so on.
Right. Separate systems.
Exactly. After 1994, they needed to be brought into the national fold. Section 1A provided a legal way to do that, to merge their records and functions into the bigger receiving registries like Pretoria, Bloemfontein, or Pietermaritzburg.
Ah, okay. So instead of a patchwork, you get one centralized system. That's a really clear example of this old act adapting to a completely new political reality.
Precisely. It unified everything, which is absolutely crucial for legal certainty, for the economy, for everything property related.
Makes sense. But who are the actual people making this system tick every day? The act mentions specific roles, right?
It does. The minister appoints the registrars, the deputy registrars, assistant registrars for each office.
And these aren't just any appointments.
No, definitely not. They need proper legal qualifications, a relevant degree or a diploma, juris. And crucially, Section 2B says they must prove appropriate expertise. It's a specialized job.
And then there's the Chief Registrar of Deeds. Sounds like a key position.
Very much so. Appointed from the existing registrars, they have pretty significant responsibilities.
Like what?
Well, managing corporate support, driving the whole ICT strategy, information and communications technology, overseeing legislation, making sure service delivery is coordinated across all the registries, even handling audit and risk. It's a big strategic role.
ICT seems important there.
Yeah.
You mentioned the chief registrar has to develop and maintain the electronic deeds registration system.
Yes, that links directly to the more recent Electronic Deeds Registration Systems Act of 2019. It's all about moving towards digital.
Pushing the system forward.
Exactly. Using tech for efficiency, security, accessibility, moving away from just paper. The Chief Registrar is really accountable for that whole digital side now.
So on a day-to-day level, what does a regular registrar actually do?
Their duties, listed in Section 3.1, are pretty extensive. They have to preserve all the records, obviously. They examine every single deed submitted.
Every single one.
Well, they examine them, but there's an interesting proviso in Section 3.1b. A deed doesn't necessarily have to be examined in its entirety before being rejected if there's a clear, upfront problem.
Oh, okay. Saves time.
Right. And they register all sorts of things. Property transfers, mortgage bonds, servitudes, even antenuptial contracts. They're basically the gatekeepers for property rights.
And can we, the public, see these records? Is it transparent?
Yes, Section 7 guarantees that. Registrars have to allow public inspection of the registers and records, though not the internal index once you pay the fee.
And everyone pays.
Everyone. The Act specifically says no person, including the state, shall be exempted from the payment of the prescribed fees. It underlines that universal access for a fee is key.
So who sets these rules and fees? Section 9 mentions a Deeds Registries Regulations Board.
That's a really important body. It ensures the Act stays practical, and look who's on it. It's diverse. The Chief Registrar, other government officials, conveyancers nominated by the Legal Practice Council, even someone from the Banking Association.
So lawyers, bankers, government, all involved.
Exactly. It means the regulations aren't just dreamed up in isolation. They get input from all the key players who actually use the system. Ensures they're workable.
Makes sense to have those different perspectives.
Definitely. It leads to more balanced, practical rules.
Okay, we've got the structure. Now, the really crucial part for anyone buying or selling, when does it become official? When is that deed actually registered?
That moment is defined very clearly in Section 13.1. A deed is registered the second the registrar signs it. That's it.
Simple enough.
But there's a key point for what are called interdependent deeds. Think of a batch where you're transferring property and registering a new bond at the same time.
Right. They rely on each other.
Exactly. In that case, none of the deeds in that batch are considered registered until all of them are signed by the registrar. It ensures the whole transaction happens cleanly, simultaneously. Transactional integrity.
That's vital. Keeps the record straight. Which brings us to this idea of the chain of title and sequential transfers. Section 14.1 seems key here. Transfers must follow the sequence of the successive transactions.
That's the bedrock principle. You can't just skim a step in the ownership chain. It ensures clarity and security of title. John sells to Mary, Mary sells to Peter. The transfers have to reflect that sequence.
But are there exceptions? Life isn't always that neat.
The Act is practical. Section 14.1b provides some really important exceptions to avoid unnecessary steps and costs.
Like what?
Well, for instance, if property goes to minor intestate heirs and there's no executor, it can sometimes be transferred directly to their heirs later on. Or imagine the cost of transferring a small piece of land to an heir would actually be more than the land is worth.
Okay.
In that case, the executor can, with consent, transfer it directly to someone who buys it from the heir. It avoids a pointless, costly intermediate step.
But you still pay the duties, right? You mentioned that earlier.
Absolutely. Section 14.2 is clear. Transfer duty is payable as if each person had received the transfer. The tax authorities don't miss out.
Good to know. Any other big exceptions?
A very significant one involves redistribution agreements. This is where heirs, legatees, maybe a surviving spouse, agree among themselves to rearrange how the inherited assets are distributed.
Okay.
The Act allows land or real rights to be transferred directly according to that agreement, even if it differs from the will or intestate succession rules. And here's a fascinating bit. They can even bring in movable property, stuff not even from the estate, to help equalize the shares.
Really? That sounds incredibly flexible.
It is. It avoids multiple expensive transfers just to shuffle assets around within the family after a death. Very practical.
This sounds complex to get right, though. Who makes sure all these details are accurate? Section 15 says a conveyancer has to prepare the deeds.
Yes, and this is where Section 15a comes in. It's a cornerstone of the system's efficiency and security.
How so?
When a conveyancer signs a specific certificate on a deed, they are formally accepting responsibility for the accuracy of certain facts needed for registration. Like, is the person transferring the property actually the owner? Is the property description correct?
Okay.
The registrar can then rely on that conveyancer certificate. They accept those certified facts as conclusively proved for their examination. It speeds things up
This
massively.
puts huge responsibility on the conveyancer.
Exactly. High accountability. It's a system built on the professionalism and liability of conveyancers. That's how these complex deals move relatively quickly, but still maintain integrity.
Right, that makes sense. So how are different types of rights transferred? Is it the same process for owning land versus, say, having a right of way?
Good question. Section 16 draws a distinction.
Yeah.
Ownership of land itself is transferred via a deed of transfer, which is executed or attested by the registrar. Other real rights in land, and a real right, is basically a right over the property itself that binds everyone, not just specific people, things like servitudes. They're usually transferred by a notarial session. That means a formal document drawn up and attested by a notary public, which is then registered by the registrar.
Got it. Different processes for different rights. What about marriage? Property and marriage must come up all the time.
Constantly. Section 17 is crucial here. If property, real rights, or even notarial bonds are part of a joint estate, typically in a marriage in community of property, the Act says they must be registered in the names of both spouses. The husband and the wife is wording, reflecting the legal situation at the time, but meaning both parties to the joint estate.
Reflecting that joint ownership.
Precisely. And deeds also have to state the person's full name, their marital status, and which system applies in community, out of community, customary law, etc. It has to be clear on the deed.
What if someone's marital status changes after they own the property? Do they have to do a whole new transfer?
Often, no. That would be cumbersome. Section 17.4, along with sections 45 and 45 bis, provide ways around that. If someone gets married, divorced, or if a joint estate is dissolved by death, that change can often just be endorsed on the existing title deed.
Much simpler.
Much simpler and cheaper than a full transfer. There's even a specific mention in Section 17.6 about spouses married under foreign law needing to assist each other when signing deeds related to property here.
Practical detail for our globalized world. Okay, but what if things go wrong? What if, say, your title deed gets lost or destroyed? Or there's a mistake on it?
The Act anticipates this. If a deed is lost, destroyed, or even just unserviceable, Section 38 provides a process to get a certificate of registered title taking place of lost, destroyed, incomplete, or unserviceable deed.
Is that easy?
It's thorough, not necessarily easy. It involves public notices in the Government Gazette and a newspaper. Then a draft certificate lies open for inspection for 6 weeks, and people can object. It's designed to be secure and prevent fraud.
Right. Proper checks and balances. And errors, if there's a mistake in the deed.
Section 4 gives registrars the power to rectify errors. They can do this if everyone involved consents in writing or if there's court order.
But they can't just change ownership through rectification.
No, absolutely not. The Act is very clear. Rectification cannot have the effect of transferring any right. If ownership needs to change, you need a proper transfer. But for fixing typos or incorrect descriptions, rectification works. There are also other sections, like 39 and 44, allowing for certificates to correct certain types of errors or remove conditions that no longer apply.
And just quickly, what about carving up land for new developments, townships and things?
Section 46 covers that. It lays out the process for subdividing land into urban or creating a township. It involves registering a general plan of the subdivision, opening new registers for each individual ERF or lot, and carefully recording all the conditions attached to those new properties, essential for urban planning and development.
Okay, let's shift focus slightly to how the Act deals with security, things like bonds, mortgage bonds, notarial bonds.
Right. Section 52 states clearly that bonds can secure debt you already owe or debt you might incur in the future, or both.
Future debt, how does that work?
Section 51 puts strict rules on bonds for future debt. It has to be explicitly stated in the bond that it covers future debts, and crucially, there must be a fixed maximum amount mentioned. You can't have an open-ended bond securing unknown future amounts.
That protects the property owner. Are there things you can't put in a bond?
Yes. Section 53 is important. A mortgage bond, which is over immovable property like land, cannot also bind movable property. And it can't contain a general clause. That's an old type of clause trying to bind all of a debtor's assets generally. That's not allowed in mortgage bonds.
And vice versa for notarial bonds.
Correct. Notarial bonds are typically over movables. They can't bind immovable property. Also, Section 54 says no bond can be passed in favor of an agent. It has to be in favor of the actual lender, the principal. Clarity is key.
What if you want to sell property that has a mortgage bond over it?
The general rule in Section 56 is that you can't transfer mortgage land until the bond is canceled or the property is formally released from the bond by the bondholder. usually through their written consent lodged with the registrar.
So you have to deal with the bond first.
Usually, yes. There are exceptions, like if the transfer happens because of a court order or insolvency, where the bond might follow the property or be dealt with differently. But generally, you clear the bond or get consent.
And can a new owner just take over the existing bond? Like, take over the seller's loan?
Yes, that's possible under Section 57. It's called debtor substitution. If the entire property secured by the bond is being transferred, the registrar can substitute the new owner as the debtor under the existing bond, provided the bondholder and the new owner both consent in writing.
So the new owner effectively steps into the seller's shoes regarding that loan.
Exactly. They take over the bond as is. Can be very practical, avoids the need for the seller to cancel their bond and the buyer to register a brand new one.
Very useful. Now, thinking about other rights, Section 63 makes this distinction again, registrable real rights versus personal rights. Can you unpack that a bit more?
Sure. It's fundamental. Generally, the Deeds Registry only records real rights. Think of a real right as a right connected directly to the property itself, enforceable against anyone in the world. Ownership is the ultimate real right. Servitudes are another example.
Okay. And personal rights?
Personal rights usually come from contracts. They're rights against a specific person, obliging them to do something or not do something. They don't automatically bind future owners of property and generally aren't registrable on their own.
Unless they're linked to a real right.
Right. Sometimes a personal right might be so closely connected to a registrable real rights that it can be included in the deed, but the general rule is real rights get registered.
You mentioned servitudes as real rights. Can you give examples?
Yeah, there are different types. We have personal servitudes, like usufruct, usus, or habitatio. Usufruct, for instance, lets someone use and enjoy property and take its fruits, like rent or crops, usually for their lifetime, without owning it. Section 66 says these personal servitudes typically can't last longer than the beneficiary's life and can't really be transferred to anyone else except back to the owner of the land.
Okay, tied to a person. What about the other kind?
Those are predial servitudes. These benefit one piece of land, the dominant tenement, over another piece of land, the servient tenement. The classic example is a right-of-way. The owner of land A has the right to cross land B to get to the road. Section 75 deals with these. The right attaches to the land, not just the current owner.
Got it. Finally, under the section antenuptial contracts, many people deal with these.
Very important. Section 86 basically says they need to be registered to be effective against third parties, like creditors. If you agree with your spouse to exclude community of property but don't register the contract, it might only bind the two of you, not the outside world.
And how do you register them?
Section 87 lays it out. They must be attested by a notary public and then registered in a deeds registry within 3 months of being signed, or 6 months if signed outside South Africa. The good news is registration in any one deeds registry counts for the whole country.
Good tip for anyone planning nuptials. Before we wrap up with modernization, any other quick but key points in the Act?
A couple jump out. Section 91 is important. You cannot disguise a loan security arrangement as a transfer of land or cession of real rights. A mortgage bond is the proper way to secure debt against land.
Prevents sham transactions.
Exactly. Also, Section 92, taxes first. No transfer gets registered unless all taxes, duties, and fees related to the property have been paid. The receiver of revenue gets their due.
Always.
And Section 93 deals with recording name changes on deeds if a person or partnership changes their name legally. Interestingly, it specifically excludes changes of surname for spouses due to marriage. That's usually handled differently if needed.
And Section 93 has that remarkable part about offensive names.
Yes, Section 93. It allows the minister, after consulting the owner, to order that the name of movable property itself be changed if the existing name is deemed offensive because of the racial connotation thereof.
That's quite something to find in a 1937 Act. Shows real evolution in thinking embedded right there.
It absolutely does. A powerful reflection of social change and redress, finding its way even into foundational property law.
Which leads us perfectly into how this nearly century-old act has stayed so relevant. How does it manage it?
Adaptability is its superpower, really. Look at the sheer number of amending acts listed in its text. It's constantly being tweaked, updated, refined. It hasn't been left static. That allows it to reflect new laws, societal changes, technological advances.
Like the move to electronic registration. We touched on the Chief Registrar's duty under Section 2C, driven by that 2019 Electronic Deeds Registration Systems Act. That's a huge shift.
Massive. It's moving toward potentially faster, more accessible, hopefully just as secure property dealings. It's the act embracing the digital age.
And it's not just about the transactions themselves, is it? The Act also plays a role in broader policy. Section 10(1). That's about data collection.
Yes, it allows for regulations to collect personal info, race, gender, citizenship, nationality of landowners, but crucially, it adds only for statistical and land audit purposes.
So why is that important?
It shows the Act supporting government needs for data, perhaps for things like land reform analysis or planning. But that only is a vital safeguard. It limits how that sensitive data can be used, protecting privacy while still allowing for necessary data gathering for policy. It's a careful balancing act.
Balancing public good and private rights. Finally, accountability. If something goes wrong in the registry, who's responsible?
Section 99 deals with liability. Generally, the state and officials are protected from liability for errors unless, and this is key, unless the act or omission was done mollified in bad faith or without reasonable care and diligence.
So negligence or bad intent opens the door to liability.
Yes. And if an official acted in bad faith, they can be personally liable to the government for any damages paid out. Plus, there's now Section 99A, a specific criminal offense for anyone performing deeds registry functions without authority, like unauthorized execution or attestation of a deed. It carries penalties of fines or even imprisonment.
So high standards,
Right.
backed up by potential liability and even criminal charges.
Absolutely. It underscores the immense trust placed in the system and the need for integrity.
So wrapping this all up, what's the big takeaway for listeners about the Deeds Registries Act?
I think it's that this act, through its detailed rules, its processes, its security features, really provides the stable foundation for property rights and, by extension, economic activity in South Africa. It's proof that old laws can stay relevant if they're allowed to evolve. It gives certainty.
It really does. And looking ahead, especially with this big shift towards electronic deeds registration, it leaves you with a question, doesn't it? In this digital age, how do we keep evolving these traditional ideas of deeds and physical registries? How do we balance the demand for speed and digital access with that absolute rock-solid security of title that this 1937 Act has provided for so long? What new challenges, but also opportunities, will the electronic system bring for all of us as property owners? Something to think about next time you hear about a property transfer.